They're determine how they're assessed. I'll kind of touch on some of these and go through them relatively quickly. The SEC pre-suit investigation, use their people making a case. This is even before this step, you typically have someone coming forward. There's the SEC whistleblower program. It was established, unfortunately, it was established in 2010, excuse me, after Madoff, and in large part because of Madoff and the market crash of 08 as well. But so it was established pursuant to the Dodd-Frank Act, and it says that specific, timely, and credible information could equal a reward of 10 to 30% of the monetary sanctions collected by the SEC against an actionable defendant, and it provides various protections for the individual who comes forward. So the SEC will tout very clearly that since this program, this is where a lot of these Ponzi schemes are unraveled, because somebody comes forward and otherwise it wouldn't have been on the SEC's radar. And so in comes the investigation. Sometimes it's behind the scenes before the action is filed. Sometimes it's quote unquote cooperative with the target, as Cliff mentioned, with the target letter and saying, hey, we're investigating you. Would you like to come in and explain your side of the story? And so they come in. A lot of times, these individuals, and Cliff may have experience on this as well, but in my experience, they come in and assist and cooperate because they're hoping for leniency or get the good graces with the SEC and the Department of Justice. But oftentimes, some of these folks, I think they come in thinking they're untouchable. I'm the smartest individual in the room. Yeah, sure, I'll come meet with you because I'm not doing anything wrong, and even if I know I'm doing something wrong, you're not going to figure it out. And so, but in any event, the FBI often assist with these investigations. And you eventually get to the lawsuit stage. So the SEC will bring a civil complaint, and oftentimes the U.S. Attorney's Office will, through the Department of Justice, will bring a parallel criminal complaint. So they're both running on the same track, and oftentimes making the same causes of action, just in a civil and a criminal context. Invariably, in the civil context, there's a motion to appoint a receiver, which is right out of the gate, emergency hearing, and for obvious reasons, you want to get that person appointed before books and records and hard drives and things start going out the door. And so the receiver is selected by the SEC. Typically, courts have the ability to appoint their own receiver, but typically they take the suggestion of the SEC. It used to be more repetitive in who the SEC selected as a receiver. So you had your typical 1 or 2 or 3 receivers in the Northern District for the SEC, and 2 or 3 in the Southern District, et cetera. But now they've started more recently doing a more diverse population of various receivers, and they try not to repeat, just so the receiver is supposed to be the neutral party. They're not an arm of the SEC. They're technically an arm of the court. They are the judge outside the courtroom. And so I think the optics from the SEC's perspective is, if we're picking the same person over and over and over again, they work with us and they work for us, we're one and the same. And that's really not supposed to be the case. The receiver is supposed to be independent and should be independent. That said, it's still a pretty small community of receivers. I'm actually a member of an organization called the National Association of Federal Equity Receivers, NAFER, where we get together, quarterly from across the country and kind of share ideas and share, hey, this is what we're seeing in our jurisdiction, or hey, this is what happened recently. So it is a pretty small knit community of folks who are sharing resources. So again, the motion's heard pretty much on emergency basis, excuse me. There's the order of appointment gets approved. Typically, my appointment orders are very broad. The ones you see in these SEC receiverships are very broad. It's, everyone is enjoined from doing anything with respect to anything that could be construed as receivership property or property of the defendants. Banks must cooperate. The U.S. Post Office must change the address to reroute everything to the receiver. Receiver has the ability to change all the locks and take possession of the real property. Law enforcement can be used to assist the receiver. I mean, very, very broad to really cast a wide net to get as much of a state property as you can. And like I touched on earlier, a receiver can be a receiver in the civil context, but it also could be a trustee in the bankruptcy context. And oftentimes they're very analogous in their powers. And then the receiver takes over. Usually whoever that individual is has free suit notice that the SEC is going to choose them. They kind of get their team together. I call Cliff. I say, hey, get your guys ready. And so you have your go team ready to kind of immediately act when the receivership order is appointed. So as soon as they're signed, so as soon as the gavel drops, your team is ready to go. Taking over operations is kind of a loose term on the bullet points, because there are really no operations. But in reality, you go in, you separate the employees from their workstations, you interview employees, figure out kind of who knows what, who's going to be on your side, who's going to be working against you. Obviously, you need to secure all the hard drives and everything that could walk out the door. And you start freezing the bank accounts and kind of going from there, and let Cliff and his team come in and start looking at what the data shows and really building the case for the fraudulent transfer actions and the clawbacks and various things like that. And so that's where you get into the pursuit of recovery. You do your due diligence, and then you kind of figure out who your targets are going to be and what you need to do to get those monies back. And then once you've determined that there are going to be monies to collect and distribute, then that's where you come up with the claims process and kind of figure out what the deadline is for folks to establish claims and the flip side of the coin to figure out, well, we know now how much we think we're going to collect, whether that's 5 cents on the dollar or 95 cents on the dollar, in the Madoff case. But the flip side of the coin is, okay, what's the totality? What's the universe of folks who have been wronged, and that'll help you determine what your pro rata distribution is going to be on all those claims.